Okay.
Hello, welcome. Welcome to the call. Give it just a minute here. Hope everyone had a great break last week, had a chance to rest and rejuvenate. Welcome back. Okay, I think we have critical mass. Romany, is it okay if I get started? Welcome, everyone. Thank you so much for taking time to join us on this call today. My name is Lauren Bradley, and I serve as the director of the Sustainable Cities Fund. It looks like many of you had a chance to join us at a webinar that we had a few weeks ago with our friends and colleagues at the Sabin Center for Climate Change Law, and we're really delighted to be here again with them today to give you kind of a refreshed presentation on what we covered last time and also offer some new insights that have come up for them since we have gone through the election and are heading into 2025. Just a couple of housekeeping items for you all to know. We are recording today's session, so we'll make the recording available to you and others who weren't able to be here today. We're going to leave some time for Q&A, question and answer at the end of the presentation. So if you have questions that come up for you, you can put them in the chat as we go. The reason why we wanted to host this call again at the Sustainable Cities Fund is we are continuing to really be laser focused on IRA deployment and implementation. It is still a high priority for us as it has been over the last 18 months. And we want to make sure that we, along with you, our grantees and our partners, have information at your fingertips to know what it means to you as you are looking to secure federal funding, as you're pursuing tax credits, as you're looking for ways to accelerate implementation of key programs. So hopefully this information is useful to you. You can apply it in those efforts. We're also looking at it informing our investments and our support of you in this work and how we can kind of reload capacity out there in the field to make sure that this work continues forward in 2025. So with that, I will turn it over to Romany. She is going to kick us off in presentation, and we'll also hear from Amy Turner today. So Romany, I'll turn it over to you.
Great. Thanks, Lauren. And hi, everyone. My name is Romany Webb. I'm an associate professor here at the Columbia Climate School and the deputy director of the Sabin Center for Climate Change Law at Columbia Law School. My colleague, Amy Turner, is joining us. Amy leads our city's climate law initiative and is our resident expert on the Inflation Reduction Act here at the Sabin Center. So we are happy to have the opportunity to talk to you again about the status of implementation of the Inflation Reduction Act. As many of you will know, the Act includes around 120 different climate-related provisions, and those provisions are being implemented by over a dozen different federal agencies. As I'll talk more about today, those agencies have already actually made a huge amount of progress in implementing the Act, but there's still a lot of work to do, and the change in administration will have implications for whether and how that work gets done. So we want to talk today about where we currently stand with implementation, what might change, what the change in administration might mean for IRA programs, and some of the things that we should all be thinking about as we move into this new world. So, share some slides here. So at the Sabin Center, we have since 2022 been tracking implementation of the Inflation Reduction Act. We developed, together with the Environmental Defense Fund, a freely accessible online resource called iratracker.org. It includes a database of all of the climate-related provisions in the Inflation Reduction Act, organized by federal agency. It also includes a tracker that records actions those agencies are taking to implement the different provisions. And so you can find in the tracker, funding opportunity announcements, RFPs, requests for information, notice of hearings and other things like that related to IRA programs. As some of you may know, using data from the Inflation Reduction Act tracker and other sources, we recently published a report that looks at the status of implementation of the climate-related provisions in the IRA and what might change under the next administration. And we focused in that report primarily on the spending programs and the tax programs in the Inflation Reduction Act. So on the spending side, the Act allocates about $142 billion to federal agencies to support action on climate change. The bulk of that money, about $105 billion, is for grants and similar awards to third parties. We have sought to determine sort of how much of that money has already been spent, how much is likely to go out the door before President Biden leaves office, and then how much may remain unspent and what may happen to that money once President Trump takes office. We'll talk more about that in a minute. We also looked at the tax programs in the IRA. The total value of those programs is actually quite difficult to estimate for a few reasons. One is because they depend on uptake, and for the most part, in most cases, the tax credits are uncapped. But some of the recent studies that have been done and modeling that's been done suggests that up to $1.2 trillion could be claimed over the next 10 years. Whether that happens will very much depends on steps that the next administration takes. So starting with the spending programs, this chart reflects the status of spending programs as of mid-July. Of the $105 billion that's allocated for grant and similar spending programs under the IRA, about 12% is what we call administrative funding that was basically appropriated to federal agencies to use internally. Because that funding is used internally and doesn't result in external awards, we can't say how much of it has been spent, but we do know that agencies have been making use of that money, and we think a good chunk of it has been spent. The awarded category that you see here, the 37%, that reflects amounts that federal agencies have awarded to third-party recipients. We consider funds to be awarded if they have been committed by contract or other binding enforceable allocation mechanism. So this awarded amount does not include funds where a recipient, an awardee, has been announced, but the contracting is still being done. For the most part, those amounts are included in our pending category, which is about 15% of the total. This pending category reflects amounts that we expect, based on federal agency announcements, to be awarded before President Biden leaves office. So basically where an awardee has been announced and the award agreements are currently being negotiated, and those negotiations are expected to wrap up by January. The available category includes funds that were tied to an open funding opportunity announcement or RFP as of mid-July. Since then, many of those open RFPs and funding opportunity announcements have closed, and in some cases, awardees have been announced. Sometimes the contracting has even been done. So since mid-July, when we compiled this data, there has been some movement in these categories, but overall, we estimate that around 50%, likely a bit more, of the money allocated under the IRA has already been spent, and another quarter, again, potentially more, is likely to be out the door before President Biden leaves office. Even so, despite this really incredible progress in allocating money over the last 2 years, it is likely that some of the funds made available under the IRA may remain unawarded at the time President-elect Trump takes office. This is a breakdown of our spending data by agency. This is not all agencies that have allocations under the Inflation Reduction Act, but some of the largest ones, and this is agency spending in millions of dollars. You can see here that EPA has the most money to spend under the Inflation Reduction Act, and it's made really significant progress in getting money out the door. As of mid-July, it had already awarded about 70% of the funds allocated to it, and another 20% or so was pending, so expected to be awarded before President Biden leaves office. EPA is actually responsible for administering the largest grant program in the Inflation Reduction Act, the so-called Greenhouse Gas Reduction Fund, or GGRF, which aims to create a nationwide green finance network. So basically, through the GGRF program, Congress allocated $27 billion to EPA, which has made grant awards to various entities under three sort of sub-programs. The first is the National Clean Investment Fund, under which EPA has awarded about $14 billion to three entities, which will use the money to establish national clean financing institutions, so basically green banks that will provide funding for clean energy technology projects. EPA has then allocated a further $6 billion through the Clean Communities Investment Accelerator. That program is supporting 5 entities that will establish hubs to provide funding and technical assistance to community lenders in low-income and disadvantaged communities. The third program under the GGRF is the Solar for All program. There, EPA has awarded about $7 billion to 60 entities that are either creating new or expanding existing low-income solar programs to support the deployment of distributed solar on homes in low-income and disadvantaged communities. One thing that's really important to know about these GGRF programs is that the awardees, the entities that have received funding from EPA, are expected to use that money to make further grants and loans to other entities to support specific projects. Those entities, whilst they have received awards from EPA and the award agreements have been negotiated and finalized, the recipients are still establishing their own programs and have not yet themselves begun making those sub-awards. There's still some uncertainty about exactly how those different programs will operate, and so that's a space to watch over the coming months and years, and Amy will talk more about that in a minute. Some other notable programs under the Inflation Reduction Act where funds remain unspent and we may see additional movement in the next weeks or potentially months are listed here. They include DOE's Zero Building Energy Codes program, which provides funding to support the implementation of energy efficiency building codes. There are several EPA programs that still have unspent funds, including the Clean Heavy Duty Vehicles program that provides funding to states, municipalities, and others to help them expand their use of zero emissions vehicles. There's the Low Emissions Electricity program that provides about $87 million for a low emissions electricity program, including funding for community education and outreach. There's a NOAA program supporting investments in coastal resilience, and there's others as well. So that's the sort of status, the high-level overview of the status of spending under the IRA to date. I want to turn now and talk about what might happen to IRA funds under a Trump administration. For the purposes of this discussion, I will assume that Congress does not take any action, that these spending programs remain in place and aren't repealed through congressional action. In that scenario, the risks to these IRA spending programs will depend in large part on the status of implementation of the programs. So in this context, you can think about the IRA programs as falling into one of 3 categories. First, there are funds that are covered by an executed award agreement or another sort of binding allocation mechanism. They are, from a legal perspective, the most protected, the safest. It is still possible that the Trump administration will try to claw back the funds that have already been awarded, but that's likely to be difficult for reasons I'll talk about in a minute. The second sort of main category of funds are those for which awardees have been announced, but the award agreement hasn't yet been finalized. And when I say hasn't yet been finalized, I mean hasn't yet been finalized by the time President Trump takes office. Those funds are, from a legal perspective, more vulnerable. The Trump administration could, legally speaking, cancel announced awards, but it may be reluctant to do that for a variety of political or other reasons. The third category of funds are those that remain unallocated at the time President Trump takes office, and they are at greatest risk for reasons I'll come back to in a minute. So thinking about those first category of funds, that first category of funds that are covered by an executed award agreement, in order for the federal government to claw back those funds, it would have to terminate the award agreement. Each award agreement has to specify the circumstances in which or the grounds on which it can be terminated. Since award agreements are confidential, we did not look at them for the purposes of our study. But we do know from the federal contracting regs that award agreements can allow for termination in up to 4 situations, and you see them on the slide here. The first one is an important one for any federal awardees to be aware of. It says that a federal agency can terminate an award agreement and claw back funds in the event of a breach by the awardee. So if you are a federal grantee, it's essential that you fully comply with the terms of the award agreement and that you document that compliance and are able to demonstrate it to the federal agency. I also want to call out item 4 here, which says that a federal agency can terminate an award agreement if the award no longer effectuates program goals or agency priorities. That would, at least on its face, seem to give federal agencies quite broad discretion to cancel awards. But it's important to note here that federal agencies can only cancel awards based on changing priorities to the extent permitted by law. And that is a potentially significant caveat. The courts have held that program goals and priorities have to be evaluated in light of the purpose of the relevant statute. So in this case, the IRA. And that means that in order to terminate an award agreement and claw back funds on ground 4 here, a federal agency would have to show that the award is not achieving the goals that were set by Congress in the IRA. So for example, if money was awarded under a program that was aimed at advancing work on energy efficiency, a federal agency couldn't terminate that award just because it was no longer prioritizing work on energy efficiency. It would have to show that the award itself didn't advance those energy efficiency goals. And that's likely to be more difficult. Of course, we may still see federal agencies trying to cancel awards. There would be opportunities to challenge unlawful termination in court. That would, of course, be time-consuming, costly, and resource-intensive, as any litigation is. But we do think that ultimately those challenges will often be successful. Some things that awardees should think about doing to minimize the risk of clawback or attempted clawback might include really paying close attention to the terms of award agreements and ensuring that those terms are fully complied with. It will be important to carefully document compliance and to put in place structures for maintaining relevant information and otherwise being able to demonstrate compliance with award agreements. So that's where funds have been awarded and are covered by a binding executed award agreement. For our second category of funds, where an awardee has been announced, but the award agreement hasn't been executed at the time President Trump takes office, those funds are more legally vulnerable and more exposed to sort of unilateral cancellation by an incoming administration. So if your organization has been notified by a federal agency that you've been selected for an award, but that award agreement is still being negotiated, it's important to complete that process as quickly as possible. We fully understand that the process can be lengthy and complex for a wide variety of reasons, but anything that can be done to expedite the process, including beginning internal reviews and other things that are required for sign-off now, will be really important. Having said that, whilst it will be important to get agreements finalized as quickly as possible, it's still really important that awardees pay close attention to the terms of those agreements and can fully comply and demonstrate compliance with those agreements. For funds that remain unawarded at the end of January, they will be at greatest risk. There is the potential for those funds to either be reprogrammed or transferred to other non-climate programs, or they may be withheld. In the case of reprogramming, agencies can, generally speaking, shift funds between programs, provided that they are covered by the same budget accounts. There are, though, some important limits on reprogramming. Most significantly, most of the funding for IRA programs was appropriated via the 2022 Consolidated Appropriations Act. And in that act, Congress said that agencies could not reprogram funds in a way that would create a new program, eliminate an existing program, or reduce the funds available for any program by more than 10%. And so that is a potentially significant limit on the reprogramming or transfer of funds that agencies can do. There is also the potential for withholding. So you can imagine a situation in which federal agencies might just sit on their hands and fail to award funds under the Inflation Reduction Act. This would, strictly speaking, violate the Act because in that Act, Congress allocated money to various programs and directed agencies to spend the money on those programs. So in these sorts of situations where federal agencies have mandatory spending obligations, withholding requires congressional approval under the Impoundment Control Act. And any withholding of funds without that congressional approval would be unlawful. Having said that, we do think it may be difficult to challenge withholding, at least in the short term, and I'm happy to talk more about why in the Q&A if there's interest in that. I would also flag that the Trump team has suggested, you may have seen in some media reports recently, in which members of the Trump team have suggested that the Impoundment Control Act is unconstitutional. And if that view were to be accepted by the courts and the act were to be struck down, then the president could really withhold funds as he sees fit. And so that would be, there would be much fewer limits on what could be done there. I'm going to turn now and talk briefly about the tax programs in the IRA. So the IRA expanded and extended a number of pre-existing tax credits. It also created a number of new tax programs. It's important to note that for the most part, the tax provisions in the IRA directly change the tax code, and so in that sense are self-executing. With very few exceptions, no action is required by the IRS or any other federal agency to sort of implement or operationalize the tax provisions in the IRA. Those provisions create tax credits or deductions that are available and can be claimed without the IRS needing to do anything. Having said that, the IRS can and has, in some cases, issued regulations and guidance to clarify the operation of these new tax programs and generally provide sort of certainty to taxpayers that are looking to take advantage of them. Some of the tax programs in the IRA may be at risk under the Trump administration. There have been reports in the media about some tax credits being eliminated. I do want to emphasize that the elimination of tax credits would require congressional action. So the tax credits are in the tax code, and so to revise or repeal them, congressional action would be required. That is not something the executive could do unilaterally. Short of repealing or revising the tax code, Congress might interfere with the operation of tax programs by revoking regulations issued by the IRS under a federal statute called the Congressional Review Act. Very briefly, the Congressional Review Act allows Congress to revoke a final regulation that's been issued by an agency by passing a joint resolution within 60 session days of the finalization of the regulation. The precise cutoff date is a little bit uncertain because it depends on the legislative calendar, but it's likely that regulations finalized after mid-May could be at risk of revocation under the Congressional Review Act. And there's been at least 2 regulations related to IRA tax programs that have been issued since then, and so could be at risk, at least in theory. There's also the possibility that the IRS itself will take steps to sort of interfere with or limit the operation of the IRA tax programs. There are various ways that they might do that. The IRS is currently in the process of developing regulations for a number of tax credit programs. You see some of them listed here. when President Trump takes office, the IRS might halt work on these pending regulations. The IRS might also review regulations that it's already finalized. It might reconsider or change its enforcement policies and do other things that could introduce a lot of uncertainty around sort of whether and how the tax credits can be claimed. And that's particularly problematic in the tax space because tax credits are really delayed benefits. Taxpayers make an investment upfront in the expectation that they will receive a benefit later on. And if there's any uncertainty as to the availability of that benefit, taxpayers are less likely to make that upfront investment. And so these sorts of actions could actually be very damaging to the tax programs in the IRA. I'm going to hand now to Amy, who's going to talk a bit more about what this all might mean for local governments and states and community groups and others that are looking to continue to take advantage of IRA programs and otherwise make progress on climate change under the next administration.
Great. Well, thank you, Romani, and thank you all for being here. It's really wonderful to see such robust attendance and engagement in the Q&A. We're seeing a lot of really wonderful questions come in, which we'll do our best to leave time for. I have seen Romani's presentation probably half a dozen times and read her team's paper several more, and I still learn something new every time I see it. I think it really helps set us up nicely for the next stage of the work, which will allow us to drill down more deeply into some of the risks and safeguards that are in place around IRA implementation. For those who I haven't had the pleasure of meeting, I'm Amy Turner. I'm the director of the City's Climate Law Initiative at the Sabin Center, and also a senior advisor to the Sustainable Cities Fund. So I'm going to cover some of the material that Romani introduced us to, but also shift gears a bit to talk about some of the on-the-ground developments that I'm watching and to various extents expecting to see over the coming months and years. These are some of the things that are going to impact implementation of federal environmental protections and renewable energy programs at the state, local, and community levels. To put that maybe a little bit differently, there are legal, regulatory, contracting, personnel, and other changes that are going to come that are going to have implications for the work that you all do. I am, all but certain that you all have had what feels like a countless number of conversations over the last almost month about the continued critical role that subnational actors, and in particular, all of your work to support them, play in mitigating and responding to climate change. Just as you had those conversations over the last years and the last term and the 4 years before that. The idea of subnationals as leaders in the climate space is nothing new, even though the contours feel like they are changing quickly. So I'm here to start putting the meat on the bones of what all of this means. What does the transition in Washington mean for your work? What does it mean for cities, states, tribes, community-based organizations to navigate this period of transition? And I want to be clear that no one has all of the answers right now. Even with all of the prep work and the scenario planning that happened before November 5th and all of the work that has taken place since then, we are really to some extent, building this plane as we fly it. But I'm going to talk through some of the things we all should be thinking about today, as well as some of the things I'll be watching in the coming 2 months and the coming 4 years. And I don't, want to overburden anyone with the items that I'm going to speak about. Please trust that there will be a lot of allies, experts, advocates, resources watching for movement and guiding you through it. Many of those folks, I think, are on this call today, but there are many, many groups paying attention, not only to the legal aspects of what's to come in the second Trump administration, but also the political, fiscal, tax, regulatory, other changes that might take place. So I'll take a couple of minutes to talk about a bucket of things that I view as actionable today. These are the things that you can do right now to take advantage of federal programs that are still 100% in existence. And some of this will be, reiterating what Romani uplifted for us. But I just really want to hammer home that there are federal programs that continue to exist that you all are in a position to either take advantage of directly or to help those that you work with take advantage of. So the first item in that category are tax credits and elective pay. These are still in the tax code. Elective pay is still available to states, tribes, local governments, and nonprofit organizations, and the other range of eligible entities. There is nothing, to Romany's point, nothing that a president nor the IRS can do on their own to take away your right to claim a tax credit that you are entitled to. They may make it more difficult for you to claim that tax credit, but they cannot take away that underlying right that you have to that tax credit. So for the period right now, go ahead, take those tax credits. Please take maximal advantage of those tax credits. And in the coming 4 years, we will certainly be watching for changes in that landscape. We understand that Congress will likely be negotiating a tax bill in 2025. We don't know where tax credits or elective pay will fall in that negotiation process, but we will be very much continuing to watch that space. We also will be watching for changes in the way that elective pay and the tax credits are implemented. So you can imagine scenarios in which it becomes, for example, more difficult to pre-register your tax credits on the portal for elective pay or for transferability. You can imagine scenarios in which it becomes less clear where to mail your tax forms. Things like that will really influence implementation. That's what folks like me and Romany and a whole bunch of groups will be watching to help guide you through as the IRS may change some of its practices. In terms of that 2025 tax bill, if you like elective pay, if you like those tax credits, if you're using them, tell your representatives. A lot of representatives, what we've learned over the last 4 weeks, a lot of representatives don't really know what elective pay is or why they should care about it. So please, if you are, if you've gotten money through elective pay, or if you are planning projects that will bring more money into your representatives' districts from elective pay, tell them that so that they can bring that information to whatever negotiation happens around a tax bill in 2025. The next category of things that you can do right now, and again, this is very much in line with Romany's research, existing grant programs and contracts. And I'm talking here more about grant awards that have already been announced, not those that you might still want to apply for. If you have an announced grant, but not a contract, this should be priority number 1 over the next 6 weeks. As Romany talked about, signing a contract is a critical legal milestone. A signed contract is a binding obligation on the federal government. The more of those actual dollars you can get in hand, all the better, but the contract is really the critical legal milestone. What we've been learning over the last month or so is that hurdles to get these contracts signed vary widely by federal agency, by grantee, what internal requirements you might have. This is the time to do what you can to advance your particular contracting process, including if you need internal approvals, if you need city council to sign off on the grant agreement, whatever it is that might be holding you up, this should be priority number 1 right now. If you do have your contract signed, again, to Romany's point, this is a time to get internal processes in place to demonstrate compliance with those contracts. So this means having a process in place to show how dollars are being spent, to show how and when deliverables are being met, and compliance with any other terms of the contract. This doesn't need to be overly complicated, but you may want to go through your contracts line by line, and anything that's going to, could possibly come up as a way for a federal agency to allege that you are not in compliance with your contract, you want to have a way to document that. Again, if you are having trouble getting your contracts signed, consider calling on your elected representatives. This is something that, we are hearing that a little bit of a political pressure can help move things along in the federal agencies. The last thing that I'll talk about in terms of the things you can do right now bucket is the Greenhouse Gas Reduction Fund. I realize that GGRF is not a fit for all of your respective projects, but it very much remains in effect. The grantees are hard at work implementing their grants. We at the Sabin Center and others will be watching for developments that could affect its implementation. We understand that the EPA is, quote, Trump-proofing contracts to the extent they can. So, you know, we don't have all the answers at this point as to how GGRF implementation will play out, but these programs are still very much in effect, and all of the grantees are hard at work, working to get dollars out to borrowers, out to communities, out to projects, right? So if you are talking to a Solar for All grantee, if you're talking to an NCIF grantee, you can keep having those conversations. If you are talking to community lenders like CDFIs or other community lenders, credit unions, about programs that they might implement with GGRF dollars, you can keep having those conversations. I think those would be fruitful conversations to continue to have even in this period of transition. So moving along from the sort of right now bucket, a couple of other things that I will be watching early on in the second Trump administration and over the full 4 years. Justice 40 and the concept of disadvantaged communities. So the Justice 40 commitment, of course, is a pledge by the federal government to spend 40% of certain climate and clean energy funding in quote unquote disadvantaged communities. That commitment came about in Executive Order 14008, which was one of the first that President Biden signed in his early days in office. It sets that Justice 40 commitment, and it also directs the White House Council on Environmental Quality to develop a geospatial tool to identify where disadvantaged communities are located. That is the CJEST tool that we all have come to rely on. It is almost a certainty that President Trump will rescind that executive order. It is very common for presidents to rescind the executive orders of previous presidents. There would be nothing unusual about that. So we can expect the Justice 40 commitment to go away, and we can expect the definition of disadvantaged communities to become either obsolete, perhaps obscured, perhaps have a changing definition. And something I'll be watching very closely is how to map what the legal ramifications are of that if we no longer can rely on the CJEST community to define disadvantaged communities in IRA programs, as well as in places in your state or local laws that may rely on those definitions. Something else that we'll all be watching very closely is staffing in the federal agencies. And I think attention to this has only grown since the election. It is very clear, both from documents like Project 2025 and from statements that President-elect Trump has made himself, that slashing staffing in federal agencies is going to be a significant priority of the new administration. And we can expect some of the agencies that are implementing the programs in the IRA and other programs that we care about, such as the Environmental Protection Agency, to face significant staffing cuts or perhaps reorganizations of those agencies in ways that make them less friendly to approach. So I'll be watching for programs within EPA and DOE that specifically focus on state and local governments. It is likely that we will also see a less friendly staffing situation in the IRS. Over the last year or so, we've all come to really know and love our IRS staff who help us with the elective pay process and run these really amazing office hours that folks can dial into. And I think that will change pretty significantly. And so that's something that I'll be watching closely as well, and that I think we'll see resources, come to the fore to help folks navigate some of those spaces. But that could make some of these IRA programs, even if they don't go away, it could make them more difficult to implement, right? More difficult for you to get answers to the questions you need, perhaps more difficult or slower to get disbursements for your reimbursable grants, that kind of thing. Something else that I know we also, all will be watching closely is the universe of environmental rollbacks more broadly. So during the first Trump administration, the Sabin Center had a deregulation tracker where we tracked all of the first Trump administration's federal deregulatory actions in the environmental space, and we will be continuing that work in the second Trump administration. Obviously, environmental deregulation has ripple effects across the entire country, the entire economy. But when I think about, the local space that I work most closely in, I'm thinking about the power plant rules that came out over the last year, the clean vehicles rules, including the California waiver, which allows states to adopt more stringent standards developed by the state of California, and IRS rulemakings around tax credits and elective pay. So we can expect to see significant opportunities for engagement for all of you. There will be rulemaking processes associated with a lot of this. The Trump administration will have to, repeal a rule through a rulemaking process and propose a new one with a notice and comment period. So there will be opportunities for engagement in that respect. And there also will be certainly significant litigation, and there will be opportunities for engagement there. So, this is a challenging moment for our work, and one that will really give rise to significant change in the work that all of us do, all of us on this call. But it is also one in which we need to be diligent, pragmatic, adaptable, informed. For me personally, what is sort of keeping me going is the absolutely wonderful community of practice we have developed. People who work in cities and states and tribes and CBOs, and people like me and Romany who work alongside them. It is, truly a privilege to work with you all. And while I can't say that I look forward to the next 4 years or have all the answers, I am honored to do this work with you all. So I will stop there and we'll leave a bit of time for questions.
Great, thank you, Amy. Lauren, there have been several questions in the Q&A about the massive amount of capacity and resources and time that's required to do many of the things that Amy and I have recommended around getting your contracts finalized, talking to your elected representatives, all those sorts of things. Did you want to say a few words about how the Sustainable Cities Fund is thinking about capacity building in this space?
Thanks, Romany. Yes, and I appreciate those questions. SCF, along with several other funders, are looking for opportunities to provide technical assistance and support to all of the areas we mentioned, related to compliance, reporting, contracting, securing funds, and potentially preparing for inquiries or defense of funds. I mentioned in the chat a few times, we had a project this year with Lawyers for Good Government and WRI that was helping tax-exempt organizations with elected pay. And there are some considerations that we have to take when we're looking at providing legal support directly to local governments and organizations. But we're looking at ways, mechanisms for how that TA could flow, and definitely hear that it's a need. I think ideally we would launch some kind of coordinated hub of support where, we've had programs of support trying to secure these funds or go after these tax credits, and now a next wave of support that would help with compliance, reporting, contracting, and securing the funds. We're also very interested in working on the communications needs. We've heard from mayors and cities in particular who are looking for support around communications, working with local delegations, local congressional delegations, to be able to communicate the impact of these funds and tax incentives, and do it in a way that is thoughtful and productive and not necessarily harmful, because not all of our messengers and messages are going to be effective in all of these circles. So looking at communication, storytelling, and in coalition building or field coordination. We've had great turnout on this call today, and there's obviously a lot of interest in working together to address these questions and concerns. And so part of the reason why we're here today is to share what we know and what Sabin knows, but also to hear from you what your needs are, and definitely noting that continued support would be helpful.
Great, thank you, Lauren. There's a few questions in the chat specifically around the IRA spending programs, which maybe I can tick off. And then there's a raft of questions related to the tax programs and direct pay in particular. And maybe Amy will go to you for a few of those. There's a question specifically about reprogramming and the latitude that federal agencies have to shift funds between different programs. Could funds be shifted to a completely different purpose, not related to IRA priorities at all? This depends basically on how the agencies have structured their budget accounts. Agencies are allowed to reprogram funds within the same budget account. Sometimes those budget accounts can be very specific. So, for example, one of the programs that was funded through the Inflation Reduction Act is a longstanding U.S. Department of Agriculture program called REAP, the Renewable Energy for America program, I think it's called. That REAP program has its own budget account. So you could not shift funds. The U.S. Department of Agriculture could not shift funds to other programs because there's no other programs covered by the same budget account. In other contexts, agencies have much broader budget accounts, which give them much more latitude to shift funds between activities, and in some cases, those budget accounts may cover a range of unrelated or sort of loosely related activities. So at least in some situations, I would not be surprised to see agencies transferring funds to non-IRA related activities. There was also a question about, in the context of funding programs, what leeway an agency might have to change the rules or guidance for a grant program after an official award has been made. The specifics around, say, how awarded funds are to be spent and the use of those funds will be specified in the award agreement or related documents like terms and conditions documents. And so those documents will govern the spending that happens under those awards. So there are more limited opportunities for federal agencies to change, retroactively change sort of broad guidance where those award agreements have been negotiated and executed. Amy, do you want to take some of the questions around direct pay and tax programs? In particular, there were several questions around repeal of tax programs and the implications that might have.
Yeah, I'm trying to read as they like populate my screen here. So if I'm missing anything, please let me know. I see a question around our tax credits that would be applied to investments made in 2024 safe. The answer is that those tax credits are still in the tax code, and you are entitled to take them for projects that went into service in 2024. I would more expect that changes to the tax code, if any, would come in 2025 in the tax bill. We don't know if they will, but they might. And it would be very unusual to have a retroactive change to the tax code, right? You'd have some real due process violations or considerations there, I think. So yes, in general, projects that were put into service in 2024 should be, quote unquote, safe. It could become more difficult for you to file those tax credits or file for those tax credits. But your underlying entitlement to take them would not. Were there other questions on the tax credits here that I'm missing? I can come back in a minute if there were.
Yeah, there's a few questions on any sense of amendments to the IRA under the new Congress. I think it is a little bit difficult to predict at the current time. We have certainly seen the benefits, as many of you will know, the benefits, these federal investments are flowing to primarily, in many cases, red districts. And that has led to a groundswell of Republican support for the act. And we've seen several Republican members of Congress recently come out in support of the act and oppose full repeal of the act. So that to me seems unlikely, though we may see individual programs being targeted for cuts or elimination. Also, as Amy said, we expect we expect action in Congress around tax reform next year, and one might expect that several of the IRA tax provisions may be discussed in that context, and we may see changes in that context. But it's a little hard to speculate at the current time. Amy, do you want to say anything more about that?
No, happy to take I see a couple of other questions I wouldn't mind taking too. Someone asked a question about HB 9495, the nonprofit bill. So, this is something that I think is evolving in real time. This is a bill, for those who aren't familiar, that passed the House, has not passed the Senate, but given the shifting landscape in Congress, might have a better chance of success in the next term. So this is an a bill that would make nonprofits sort of more vulnerable to interrogation or audit by the IRS. So, we understand that there is a sort of significant focus on nonprofit organizations at this moment. The House Republicans recently put out a report that talked about some of the, organizations that have received grants under IRA programming. I think that there is a real mobilization among our community of practice to provide resources in this regard. This is a time to sort of sit down again and look through the contracts that you have with the federal government and, your bylaws and other terms of your tax exemption, and make sure that you're able to demonstrate compliance with all of those things. To the extent that you can make sure that your books are fully in order, that you're demonstrating that you are meeting deliverables under contracts that you have with the federal government. Those are things that you can think about right now in order to put yourself on good footing if something should come to pass. But I know that there are many, others who are thinking about how to provide more systematized support to nonprofits that might find themselves in this space. There's also a question about budget reconciliation. If Congress targets IRA provisions in budget reconciliation, does that make the agency priority risk to existing contracts more likely? Romani, I'd be interested in your views on this, but assuming that a contract was signed when Congress had a certain view of its priorities, I'm not sure that that would significantly change contracts that have already been signed. But I'm curious if you have a view on that question.
Yeah, it's a very interesting question, and one on which there is very little useful case law. There's actually very few court decisions considering sort of premature termination of award agreements and clawback of funds. When we did our study, we were actually only able to find a handful of cases from related to attempts during the first Trump administration to terminate awards early based on changing government and agency priorities. And they were all struck down by the courts on this basis that, you had to evaluate spending based on congressional priorities. I tend to agree with you, Amy, that those congressional priorities would be evaluated in light of the sort of original statute that set up the program and under which the award was made. But I think it is an open question that would ultimately need to be decided by the courts. And predicting the outcome of any court case at the moment is especially challenging given some of the changes we've seen recently in the judiciary.
I'll talk about the CPRG question. What obligations do states have to complete CCAPs under CPRG planning grants? So we have not seen those contracts. Those are private contracts between you and the federal government. So we don't know exactly what they say. Broadly speaking, my understanding is that, grantees have obligations to finish their CCAPs by their deadline. But whether there are outs in your contracts particularly, that's very difficult to say without reviewing your contract directly.
There's also a question in here about the potential impact of a government shutdown, which is an excellent question. Would I expect be extremely disruptive? But even short of a government shutdown, as Amy alluded to, reductions in agency staffing, which have been much talked about, given the focus on government efficiency, those reductions in agency staffing could have major implications for continued operation of these programs, your ability to get questions answered, to get information, to have your applications reviewed in a timely fashion. So anything like a shutdown, like reductions in agency staffing, anything like that that reduces agency capacity could be very problematic. I will also say that currently the federal government makes available a huge amount of information on IRA programs, the availability of funding, how it's being used, the tax credit programs, how they operate, etc. it would not be surprising if a lot of that information was quickly taken down or removed from government websites. So that is something to be aware of as part of our Inflation Reduction Act tracker. We do link to a number of government pages that describe various IRA climate programs, and we are going to be archiving those government websites so that they will remain available even if they are taken down. But it's possible we will not capture everything. So if there is a website that you especially rely on, please keep an eye on it and make sure you have the information that you need.
I see a couple of questions on the rebate programs that are running through the states from the state energy offices from the Department of Energy. These, of course, are rebate programs for households for electrification and energy efficiency projects. You know, the key milestone here is whether or not your state has signed a contract for those programs. You know, and again, it's hard to say more than that without seeing the actual contracts. But you know, a number of states have rolled out these programs and presumably have contracts with the DOE for doing so. Those contracts have terms that we are not privy to, but you know, there would be some level of legal obligation on the federal government to continue funding those programs. Not that they couldn't make that more difficult, but that is a very significant legal milestone. It is hard right now to say what will happen to the states that do not have programs in place on January 20th. I also have a question about sort of the rebates and their relationship to tax credits. It just appeared to, oh, there it is. Things are bouncing around on my screen. So yes, there's obviously some uncertainty around tax credits, but they are in effect now. In particular, it does seem like the individual electric vehicle tax credit is facing a good amount of political pushback. That could obviously change significantly by the time Congress gets around to negotiating a tax bill, but it does seem to be in the crosshairs right now. You know, I think my messaging here is, you know, these tax credits are in effect now, and households and residents should, businesses for that matter, should take advantage of them. Like, now is a great time to use those tax credits because they are in effect, and they will be in effect until Congress changes the law. And perhaps the uncertainty plays into that to some extent as well, right? We don't know exactly what will happen with the EV tax credit come 2025, but we do know that it's in effect now, and now is a great time to stack those tax credits with other incentives that may be available.
All right, great. Thank you, Amy. We have only 2 minutes left. There are a few questions there that we didn't get to, but we will be happy to follow up with people. Lauren, I will give you the last word in our last minute or two here.
Thank you all so much again for joining us. This presentations, Romany and Amy, thank you so much for making them. But I want to particularly thank the participants here for all of your questions in the chat and your comments in the chat. Actually hearing from you and what your questions are and what your needs are incredibly helpful to us so that we can target our research, our analysis. And as we're thinking about funding programs and assistance, just really understanding what the needs are and what would actually be helpful is really valuable to us. So thank you for your comments in the chat. We'd also love to hear from you directly as we kind of better understand your needs. We're continuing this work. We're continuing. There's some questions we don't know the answer to, and there's some that we're digging into more deeply. So I suspect we will have another webinar soon when we have another batch of information to share. So please stay tuned for that. But in the meantime, if you have questions or needs that you want to make sure are on our radar, please reach out. We'd love to know what they are. Thank you so much for all the good work that you're doing in your cities and states and counties and in your organizations. We really appreciate you all and look forward to seeing you soon. Take care, everybody.